Today in this video we are going to see about the lease. The lease deed formed by an agreement which is coming under the Transfer of Property Act 1882, section 105 to 18 we will see in this video. In the second video we will see from 109 to 117, section 109 to 117, which also covers the lease deed. First we will see the in Tamil it is called Kuttagai. So first we will see what is meant by lease. The lease is defined as the transfer of right to enjoy the property made for certain time, express or implied or in perpetuity, for a consideration or a price paid by lessee. So there will be two contracting parties. One is called lessor and another is called lessee. So the lessor transfers the property to another for his enjoyment and for a consideration with a period of maybe short or long period or in perpetuity for a consideration. That consideration may be money or share of crops or service or any other value. That is called consideration. Consideration means one for another, quid pro quo. For giving one thing they are receiving another thing, that is called consideration. And so what the things happens in lease, one party transfers his property right to another person called lessee for a consideration. And before going to see the other things, we will be telling about what is ownership, what is possessory right. Ownership and possessory right, if a person is having both together, he is the absolute owner. That is called right in rem. That is, suppose say for example I am having the title deed of the land or a house or a property, where I am also possessing it, I am using that property. Say for example I am dwelling in the house, I am also having the deed, title deed. So I am the absolute owner. So the whole world has to respect that property, that is called right in rem. Suppose I am holding the title, that is the property ownership, and I am giving the possessor right, that is for the enjoyment of the property, that right I am giving to another, that is called possessor right. So usually the possessor right is 1/10 of ownership. So the person using the possessor right is always said to be 1/10 of ownership. So whenever we are giving the property for the enjoyment of other for a sum, we should be very careful in getting the agreement and how the land should be used, what all the payment should be made for the enjoyment, those when it should be evicted, those things are to be clearly spelled out in the agreement. So that is the important thing in the lease. So now that is the important thing. Then we will see the terms used in this section, that is in this lease deed. First the lessor. The lessor means the transferor of the property. The owner of the property is called transferor. So whenever R comes means a person who is giving is called R. That is say consignor, consignee, payer, payee, vendor, vendee, like that. Lessee means the transferee, one who gets the property for his enjoyment, for a price or for a consideration for a fixed period, that is called transferee. And the premium means price is called premium. and then the rent is in the form of the money, service, or a part of the crop or share of crops. These are all called rent. So these words, we should familiar with these words. Then another thing, then we'll see the lease, rent, and that is differentiation. The lease is the that is the one can exercise the right, exclusive right is given to the lease, the person who is taking the lease. Rent is not the exclusive right, that is whenever and the rent can be for a shorter period, for every 11 months it should be renewed, but the lease for even shorter period, 6 months or months, or even for longer period, even for 99 years. And that is the difference between lease and rent. So rent is always by rental agreement for 11 months. The validity is 11 months, and whenever the 11 months is over, it has to be renewed again and again. But the lease is also to be renewed. But the thing is, if it is for a month, in 15 days a validity, it should be renewed. Say for example, January 1 to January 31, and February 1 to February 31, like that month wise lease also can be given, but on the end of 15th days a notice to be given, and again another fresh lease to be formed. It need not be in writing in the document, even in oral also lease can be done in case of short periods. And in case of lease and license, lease is the exclusive right that it creates an interest in property, and for unreasonable period, that is it is for more period. License is exclusive, that is the exclusive right is not given in the case of a license. Only can have the possessor right, that is called license. And this can be clearly explained in the case study of State of West Bengal versus Thakuram. The right to catch a fish in a pond, whether it is a lease or a license. It has been decided by the court that a right to catch a fish is only a license and it is not a lease. So it has been termed as a license. Like that, in the Urimum, license means Urimum, that is in railway stations also, in the platforms there will be lot of stalls. There they are giving permission to run the stalls, that is also called a license. That is the exclusive right is not with the person who is taking the license. Then case study, in this case study also we will see the test for license from lease it can be studied from misquality cut pieces versus Mrs. Lakshmi and Company, All India Reporter 1986, Bombay, page number 359. In this case study, test for license from lease has been given in this. That is, the departmental service stores, whether the departmental service store run by the people, are they coming under lease or the license. So it has been decided by the court as it is license only, it is not lease, because the DSS, Department of Service Store, owner of several stalls, they own several stalls, and naturally if that is the case, that becomes license. Then are there tenants and licenses? The stall holders have no exclusive possession. Second thing, business hours are also decided by the DSS, Department Service Store. And third one, the watchman, the accountant, and then the statistician are all employed by departmental service stores, and even the sales are monitored by departmental service store. So this comes under lease, as far as the case study of Miss Quality Cut pieces versus Mrs. Lakshmi and Co. Then another case study, that is Kabali Ahmed versus Tufal Hussain, AR 1983, Supreme Court 189. That is, if document is a lease, then the tenant is having the right to have the leasehold, and also they are governed by Rent Control Act. So the lessor cannot evict easily. So whenever, if it is a lease, if the document is of lease, the tenant is having the right of the Rent Control Act. What all the rights told in the rent control, they also hold. The leaseholder also can have that right. So the eviction cannot be done by the owner easily. Then we will see the what is joint tenancy. Joint tenancy means then two people are combined and the tenancy is entered, or a lease is entered. Then the case study is Inderjit Singh versus Turlochan Singh. In this case study, they have actually had a the plot, and then superstructure has been built in plot. Then it is partitioned by mids and bounds. Mids and bound means the boundary. Then lessor permission not needed. So the each and every tenant can have their own mids and bounds. That is called joint tenancy. The lessor permission is not needed. So that is as regards the joint ownership, joint tenancy. And then now we will see the next section, section 107. Suppose if the lease is more than 1 year, definitely there should be a lease agreement must be registered. It should be in a stamp paper with proper stamp, and also it has to be registered in the register office, otherwise it is not valid. So whenever the lease is for more than 1 year, compulsory registration is necessary. Then sublease. Regarding sublease, the owner, unless until it is provided, the contract is provided by the lessor, sublease is also allowed. And the subtenant, that is actually the lessor is there, the tenant, and then the tenant giving sublease to another tenant, that is called subleasing. So if at all, if the first tenant asks to evict, then naturally that the subtenant has to oblige the first tenant, that is the owner, or the landlord, or the transferor, or the lessor. Then then we will see the rights and liabilities, section 108. Rights and liabilities of the lessor. Lessor means the owner or the person who gives the property for the enjoyment of other, that is to the lessee. So the rights and liabilities of the lessor, that is caveat emptor. Whenever you purchase a property, the buyer is beware of all the things. The buyer cannot say at later date that I don't know this, I do not know that. These things cannot be told. That is called the caveat emptor. The buyer shall beware of the things. So that is the caveat emptor. Then actually the transferor or the lessor should give the possession of the land or the property to the, that is immovable property, to the lessee. That is another liability of the lessor. Then the free and quiet enjoyment of property. the free and quiet enjoyment of the property is to be given to the lessee, that is the liability of the lessor. Then the lessor to identify the losses. If at all, if inherent loss is smelt by the lessor, that should be compensated to the lessee. That is, this is to identify the loss while enjoying the property. Then the lessee get both the right and liability. So the lessee get both the right and liability. Then section 108 in another the same section, the right and liability of the lessee. We have now, so far we have seen the right and liabilities. Liabilities means responsibilities of the lessor. Now we will see the rights and liabilities of the lessee. So first we will see the accession. Whenever a land is there, naturally there will be some accession. They suppose if the land is on the branch of the a river, on the bank of the river, then due to the natural course of the river, it may shift the river may shift the course. During summer time, due to water receipt, there may be land, there may be excess land, and during rainy season, they due to erosion and all, there may be less bank or the space will be less. So the adjacent landowner can have accession over that the public land, provided if it is whenever it is demanded, it has to be given. That is called accession. So the accession right is with the lessee. But the thing is, if at all, if it is in the encroachment, that has to be given to the lessor. What are the encroachments? Without the encroachment, the other things, what is in the deed, that should be given back to the lessor. Then when property is damaged, the suppose due to riot or due to some political vendetta, the property may get damaged, then the liability rests with the lessor, because he has not enjoyed the property to the full extent. So that is their liability rests with the lessor. Then return of property as is varies basis. Suppose there should not be any material damage should be there. Suppose the structure already available should not be damaged or modified. That is, the return of the property as is varies basis means the lessee have the responsibility to return the property as it was obtained from the lessor. That is called as is varies basis. Then the crops and other things, the standing crops, if at all is there, then that belongs to the lessee. Then the right to sublease, right to sublease also allowed, provided if it is not written contrary in the agreement. Then disclosure of, that is the incomes derived from that. Some of the additional incomes, if any is derived from the property, that has to be disclosed to the lessor and it has to be given to the lessor. Then the payment should be given to the lessee as agreed. That and maintenance of property belongs to the lessee. Then the due care and diligence should be taken in the property. So what are the as if it is his own, that should be the maintenance and other things should be with diligent, due care and diligence is necessary for the property. So it is the duty of the lessee to maintain the property. And then no permanent structure without the permission of the lessor is allowed. And then the possessor right is with the lessee. These are all the rights and liabilities of the lessee. And then section 108 also says the termination of lease, that is under what condition the lease comes to an end, that is called termination of lease. So expiry of time or efflux of time, when the time is over, then the tenor or the tenant or the transferor has to give back the property to the landowner, that is called the transfer. Then by efflux of time, then termination of notice, when the notice comes to an end, then he has to give the property to the landlord or the transferor. Then if at all, if the conditional lease is there, then it also come to termination. Then forfeiture, what are the forfeitures means, that is the surrendering thing. When the breach of condition of payment, when the payment is not done properly, then it is breach of duty, breach of care and breach of the contract. So naturally the lease comes to an end. Then the lessor denying a lessee title. So when the lessor denying the title to the lessor, then also the termination of lease ends. Then insolvency of tenant, suppose if the tenant is insolvent, then the termination can happen. Merger means, suppose if the lessee have the property or owns the property by paying the amount to the lessor, then it is coming under merger. So by that way the original lease deed comes to an end. Then surrender express or implied. Sometimes the surrender of thing wantonly, expressly or impliedly, then the termination of lease comes to an end. So as regards the lease property, since the lease property comes to lakhs and lakhs of rupees, the owner should take utmost care in dealing the lease deed. Even they can seek the help of an expert also while forming the lease deed, because the what are the terms and conditions, that should be pakka and it should not be revived, so that because whenever we have more than one house or more than the property goods like that for commercial purpose, naturally we have to give it for rent, because it is income generating business both for the lessor and lessee. So this lease deed is compulsory, and it should be registered. It should be registered for if it is for more than 1 year, and if it is for more than for 1 month, 15 days notice should be given. Then if it is for 1 year, 1 month's notice should be given. And if it is less than 1 month, even oral oral lease can also be done. These conditions are to be suited for the completion of the lease. And the remaining thing 109 to 117 we will see in the second video. With this we complete the English version, and in Tamil, ஒரு குத்தகை என்பது, ஒரு குத்தகை விடுபவர் குத்தகை வாங்குபவர் உள்ளார், அதனை ஒரு டாக்குமெண்ட்டில் எழுதி நம் குத்தகைக்கு விடுகின்றோம். அதில் ஒரு வருடத்திற்கு மேலாக 99 வருடத்திற்காக செய்யலாம், ஒரு வருடத்திற்கும் செய்யலாம். அவ்வாறு செய்யும் பொழுது அதனை ஒழுங்காக எழுதப்பட்டு கண்டிஷன் போடப்பட்டு எழுதப்பட வேண்டும். ஏனென்றால் 1/10 of possessory right, that is ownership right is with the possession. So we should be very careful in lease deed. With this we conclude this lease.